Hello everyone, so welcome back to my English Law channel. I'm going a little bit further with damages this time. So when damages are awarded, there are four factors which will keep the amount of damages down. The court will take into account causation, remoteness, mitigation, and contributory negligence. So we'll go through those one by one. Causation. What actually caused the loss? You have to prove a cause and effect relationship between the breach of the contract and the loss. There might have been a breach of contract which led to no loss at all, or the contract was going to, or the loss is going to happen anyway. So the one about when it's difficult to show that there's a causal link between the breach and the loss later on is Gulu against Bright Graham Murray in 1994. Where it was debated whether the breach was the effective cause or the dominant cause of the loss. So what was I going to say? So it's post proctor hoc ergo post hoc ergo propter hoc. That was the sort of logical fallacy. Just because one event succeeded another, it doesn't demonstrate that the second event was occasioned by the first. Or there could have been novus actus interveniens, as in some extraneous event came along and that is what caused the loss. If the loss was consequent upon something other than the breach, then damages shan't be recoverable and perhaps the loss was likely to occur anyhow. So Lambert against Lewis 1982 or Monarch Steamship against A.B. Carl Shams 1949 is a similar case in point. Coming back to remoteness, are the losses too far from the breach, only tangentially related? So Hadley and Baxendale is a case about that in 1854, when the judge held where two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such a breach of contract should be, as may fairly and reasonably be considered, for either arising naturally, i.e. according to the usual course of things, from such the breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as a probable result of breach. Close quotation. So the damages awarded have to be what one would have expected when forming the contract would be awarded if such a breach happened, or the sort of damages which would normally be paid, which would be sensible and foreseeable to be paid in the event of such a breach being committed. Let's now look at remoteness. Well, there are two limbs to the remoteness test. First of all, did the damage occur naturally? Was it in the ordinary course of things? Was it unavoidably in the minds of both the parties? So we talk about imputed knowledge, which is an objective standard. Not what do the parties actually believe. We can't read their minds. They might be unreasonable people. What would a reasonable man in that position think? So we're not being subjective and saying what did they think, because they might have been foolish or illogical. And the second limb of the remoteness test is did the damages come from some extraordinary circumstances which needed actual knowledge by the defendant to be in his reasonable contemplation, to be in the reasonable contemplation of both parties, not just the defendant, also the claimant. So sometimes they can consider this a subjective test actual knowledge if these are extraordinary losses, such as one would not anticipate. So Jackson against Royal Bank 2005 is a case about that. So carrying on the remoteness test, Victoria Laundry against Newman Industries 1949, the appellate court had to consider this, or Kufos against C. Charnikov, the Heron number 2 1969. It was a shipping case that went to the House of Lords when they said that the loss was not likely to occur. Therefore, it didn't pass the remoteness test. If it's too remote, damages shan't be recoverable. Balfour Beatty Scotland against Scottish Power 1994. So this was the construction company against the electricity company. And they said that there was a very substantial degree of probability that the losses would occur. Remoteness is also considered contextually. The usual approach is as per Hadley against Baxendale, and this was restated in Heron number 2, and that usually holds water. So this traditional attitude might be inapplicable if the industry standard says that particular losses, even if they are reasonably foreseeable, are not intended to be recovered by the parties. That's not trade practice. So there was the Achilleus 2009, a case heard by that South African judge in the House of Lords, Lord Hoffman. He said it must in principle be wrong to hold someone liable for risks for which the people entering into such a contract for their particular market would not reasonably considered to have undertaken. Close quotation. So there are losses which happen all the time in certain sectors, and that's just part of life. If you do business in that sector, you accept that as one of the downsides of operating in that sector, in which case such losses shan't be recoverable. So looking at the context of working in a particular area of the economy. And this was upheld in Supershield Limited against Seaman Building Technologies 2010, and in John Grimes Partnership Limited against Gubbins 2013. Coming on to mitigation, you are not obliged to mitigate, perhaps surprisingly, but losses which occur as a consequence of not mitigating are not recoverable. So what do you need to do if you want to be able to recover losses? You must take reasonable steps. That's the expression used, reasonable steps, as in British Westinghouse against Underground Electric 1912. So the other side scores a breach, and losses are going to be consequent upon that. You must do what you can to keep those losses down, if not avoid them altogether. If you carry on performance in full knowledge that there's a breach which is going to cause you losses, and your losses mount up avoidably, well, on your head be it. Those losses could have been avoided, and that's your silly fault. So you just can't be trying to saddle the other party with unnecessary damages. So you also have to give credit for any of the benefits which arose by this mitigation. So Yobiala Business Travel SAU, formerly Travel Plan SAU, of Spain against Fulton Shipping Incorporated, the new Flamenco 2017 it was about a passenger ferry pleasure cruiser. So the innocent party who's mitigating doesn't have to start litigating. Pilkington against Wood 1953 found this, but the innocent party who's carrying out the mitigation might have to accept that the defendant's airsart's performance, if that's cost effective, the party in breach is not performing properly. They offer you an alternative. It's not a very good one, but you might have to accept that if that will at least keep your loss down. That's in Paisley against Saunders 1919. The mitigation, as was held in one case, cannot be weighed in nice scales. So it's not something we can be microscopically accurate about. Banco de Portugal against Waterloo and Sons, 1932, whereas it was a case where that was held. Coming back to contributory negligence. So one party's in breach and they're causing loss, but the innocent party might not be that innocent, and he or she has also been negligent, has also been partially responsible for the losses arising. So the Law Reform Contributory Negligence Act 1945 was about that. So contributory negligence might be available, if the breach is, first of all, a breach of a duty under the contract, or second of all, a tort, as in civil wrong, tort, T-O-R-T, meaning wrong in French. So there was a well-known case about this, and it's very difficult to pronounce this one. Forsikreins qui Xiel Capet Vesta against Butcher, 1989. Now, I think it was a Swedish company, and the judge was Hobhouse, where he made that ruling about contributory negligence. Barclays Bank against Fairclough, 1995, is another well-known case on this one, and Lord Simon sat on the case. And his noble lordship had the following to say: the imposition of a strict liability on the defendant is, to my mind, inconsistent with the apportionment of the loss. So what other remedies will be open to innocent parties here? Well, there's specific performance, where the court orders the party in breach to do what he originally contracted to do. Now, this is at the discretion of the court. The court might consider the damages are not a proper remedy in this case. For contracts of personal service, they shall never order specific performance, as in the person must do what he's decided he's not going to do. De Francesco against Barnum in 1890 is a case of that. But if it's of that you have to play the piano at the concert, you, not someone else, you can't get a replacement, it must be you as an individual. They can't order specific performance there. They might say, well, you can get someone else to do it for you, but they can't order that you as an individual do something. So the court does not want to have to superintend the contract to see that it's actually performed. In Cooperative Insurance Society Limited against Argyle Stores Holdings Limited, 1998, that was held because the court is not a nanny. Now, injunctions could be issued. These can be negative injunctions, not to say that they're bad, but a negative injunction is not to do something. You're not allowed to say something, to disclose secret information, for instance, about the Prime Minister's daughter having attempted suicide in 2004. Oops, I just let that one out. Or whatever it might be, or not to set up a business in a certain location within a certain time scale, operating in a certain trade. That's a non-competition clause. So there's some negative stipulations, as in, well, you are prohibited for doing something, so you're accepting some forbearance, some disbenefit, you are agreeing to renounce your rights in some way. That's what negative injunctions are about. That's Evening Standard against Henderson, 1987, is about that one. So let's go through the system of remedies again. It's quite tricky. So we think there's been a breach. So we first of all figure out what were the terms of the contract. Is anything excluded because it's breaking the statute or common law? We got to find out what the breach was and decide what sort of term was breached. And then we can decide whether we will see have the parties agreed on liquidated damages in advance. If yes, is this liquidated damages clause valid? If yes, then that sum is paid out. If no, then that's regarded as a penalty clause. And then unliquidated damages will be calculated by the court. Well, the court's got to decide what is the most suitable measure of damages, and then they have to weigh the various factors which might reduce those damages, such as contributory negligence. But going back to when the parties have not decided what the sum is going to be, therefore the court has to go for unliquidated damages. The court itself must decide what would be the apposite amount of damages to be awarded. And again, so then they have to decide, shall we use the restitution measure or the expectation measure? Or anyway, and having done that, then they have to take into account contributory negligence, things like that, causation, remoteness, was there loss of amenity, and award the appropriate level of damages. So it's a very tricky topic, damages. It's a multi-stage process. Another thing to bear in mind is that the parties might contract out of this, agree to release each other from the contract. There could be lots of litigation, suing each other to kingdom come. It cannot be emphasised enough. This is a case law subject. So you need to know of case law, be able to cite cases to prove things one way or the other. And in law, you can seldom say things for certain. It's usually a probably or a usually. It depends. You'll notice how unclear it is, having regard to the circumstances, or as the court considers just in the circumstances, using discretion. So judges are not robots, they're humans, and they have to use their judgments. There's a clue in the word judge. That's enough from me, so please book online lessons with me in law, history, politics, religious studies, citizenship, French, English language, English literature, even maths and science if it's sort of 13 plus or below. But I teach obviously 7 plus, 11 plus, common entrance, scholarships, GCSE, A-level, international baccalaureate. I help undergraduates and postgraduates, people with interview preparation, personal statements, essays, theses and dissertations. Toodaloo.